I'm going to do some background stuff on the law so we can understand what happened in the Dobbs case that overturned Roe and why it's going to have potentially such downstream ill effects on other constitutional rights. All right, so let's talk a little bit first about what the constitutional basis is for the right to privacy. I want to talk about the constitutional basis for the rights that many of us think loosely as the rights associated with the right to privacy, right? That's the way we usually think about it. The 14th Amendment, of course, made the guarantee of life, liberty, due process, and equal protection of the laws applicable to the states. And the court has long held that it's the basis for individual rights, including rights that we are going to be talking about today, such as the right to marriage, to use contraception, and to obtain an abortion. Sometimes people will refer to it as the substantive due process liberty right. That has been used to protect the right to consensual sex, for example, including same-sex intimacy in Lawrence versus Texas, the right to marry. The right to marry led the court to strike down bans on interracial marriage, the Loving versus Virginia case, as well more recently, the same-sex marriage case, Obergefell. It's also been the source of the right to control the timing and spacing of childbirth, striking down bans on contraception and abortion. The contraception issue, we'll talk about the basis for the right there a little bit more. The court also earlier in the 20th century held that parents had a right to control the upbringing of their children, specifically to send their kids to private school, to teach them German, which was very controversial at the beginning of the century and during the world wars. Let's talk first about reproductive rights and contraception. Griswold versus Connecticut, right there in your own home state, was the fundamental case that established the right to privacy and its impact on people's ability to control whether they got pregnant or not. It struck down Connecticut's ban on contraceptions and contraceptives and held that married people had the right to use contraceptives prescribed by their physicians. But there were a lot of disagreements in the 1960s among lawyers and constitutional scholars about the appropriate source of the right within the Constitution. And the concept of using the right to liberty in particular was a source of great dispute. All of those disputes led the court to be hesitant to ground the right to privacy in the liberty right. Instead, and these things had all been argued to the court in the main briefs and in friend of the court briefs, also referred to as amicus briefs. They looked at whether there was a right to privacy in the First Amendment, in the Fourth Amendment, the right against search and seizure, in the Ninth Amendment, which guarantees rights to the people that aren't being protected otherwise by the Constitution, and in the 14th Amendment, in the liberty right itself. Griswold decided, well, we don't know where it is, but it's somewhere within the Constitution, in what they called the Penumbras, the shadows of all these amendments. Clearly, the court meant to constitutional. The amendment was meant to protect the right to liberty. And in a concurrence, Justice Harlan said, okay, all this penumbra stuff is crap. Come on, let's just go straight to the right to liberty. That's where it is. We all know that you can't be truly free without these basic rights of privacy to control your own life. But the court didn't do it in that case. They stuck with the penumbras. Now, ironically, later, Roe gets criticized for being based on penumbras, and people will say, well, it's just this crazy thing. Roe has no good basis in the Constitution because it's in these penumbras. But if somebody challenged those people and said, well, what about Griswold, which actually had penumbras, they'd say, oh no, Griswold's just fine. But Roe, as a doctrinal matter, is really flawed because it relies on these penumbras. Now, Roe did not rely on the penumbras at all. Roe said that the right to privacy is broad enough to include the right to abortion, But as for the basis of the right to privacy, the court acknowledged all the different arguments made about its constitutional home, all the penumbras that Griswold had relied on. But they also acknowledged the right to liberty argument that Griswold had failed to adopt. And they said, we think that's where it is. We think it's a liberty right. And then they said, but it doesn't really matter because it's broad enough to cover abortion. One interesting thing too, I'll just note here, is that the right to liberty and the right to equality have often acted together to protect rights. Clearly, definitely have also been used separately. But if you look back into the middle of the 20th century, you see that they were somewhat intertwined. And some scholars have argued that the rights are completely dependent on each other, and you can't have one if you don't have the other. You can't be truly equal if you don't have a right to liberty. You can't have liberty, certainly, without the right to equality. The case that struck down the ban on interracial marriage, the court relied on equality rights, have equality to marry, equal right to the right to marriage, essentially, which protected equally white and Black people, which was really how they were thinking about race in those times, protected them equally, which meant they could marry whoever they want. Roe said that women have a protection for abortion under the Constitution, under this right to liberty. In 1992, almost 20 years after Roe, a case that became very important was Planned Parenthood versus Casey. And Casey reaffirmed what it called the central principles of Roe, which were three things: the right to obtain an abortion before viability, the right to obtain an abortion post viability, where the pregnancy endangered a woman's life or health, and the idea, which is related to that women's health must always be the paramount consideration in physicians' ability to provide an abortion. So they must always have the right to act to protect the woman. In Casey, they made changes to the standard of review. Roe had applied what's called strict scrutiny, which is the toughest standard. And it requires, if the court finds a violation of a right, it requires the state to come back and prove that there's the most important interest that it has, what they call a compelling interest, and that it's narrowly tailored to serve the right. It's very hard to meet the strict scrutiny standard. Casey said that the state could regulate to ensure that the woman's choice was fully informed. And it said we need to give a little more credence and a little more protection to the state's interest in protecting potential life. Roe didn't pay enough attention to that. Some people argue Roe paid too much attention to that. But putting that aside, Casey lowered the standard of review and changed the standard of review to what was called the undue burden standard. Under the undue burden standard, the regulations would be struck down if they had the purpose or effect of imposing a, quote, undue burden on the woman's ability to obtain an abortion. What that did, because they're saying undue burden, they defined undue burden as a substantial obstacle. And like many things legal, substantial and undue are concepts that what do they mean, right? We have to figure out what they mean, and different people will have different views of what they mean, just like people have different views of liberty. But so cases were challenging these notions of what was undue and what was substantial about an obstacle. And in effect, what ended up happening was that we lost tons with Casey, and it essentially was the beginning of the end. That's where we get regulations on clinics that force them to shut down because they're imposing unnecessary requirements on the clinics and on physicians. And we got what we now call abortion deserts throughout the country because people simply couldn't keep clinics operating in many locations. And there was great unfairness on racial lines as well, because in the big cities, there tended to be abortion clinics, but access became more and more limited. Travel became more and more expensive. Low-income people, minority people had a harder and harder time. Rural women in particular had a great difficulty in obtaining abortions unless they had tons of money and they could fly wherever they want. One note about sex equality, the equality arguments, the idea that restricting abortion is imposing a burden on your right to equality as a woman, that was actually argued in Roe in amicus briefs, but not in the central briefs. And we have to remember that women didn't get the right to equality under the Constitution until like 2 years before Roe. So the idea of protection, of constitutional protection for the right to equality of women was still quite new. So it wasn't fully argued in Roe, and Roe does not make any mention of it. What Casey did, although it reduced the standard of review, made it easier for states to regulate, it was the first controlling opinion that said that women relied on the control of their childbearing for their ability to participate equally in both the public and private spheres of life, their ability to be equal citizens. So the sex equality notion starts coming in and being part of the liberty right, in fact, in that case. They also rejected a spousal notice requirement, saying that the idea that the husband controlled the wife and could stop her from doing what she wanted was also an outmoded view, and it made it illegitimate. We can argue about whether that was the only basis or not. There was certainly other discussion about the imposition of the spousal notice requirement and the effect that that would have on women obtaining abortions, particularly if they were in an abusive relationship. I think I said before that the rights of liberty and equality were entwined, and they were present in these other cases. After Griswold, in fact, Eisenstadt versus Baird, which some of you may have heard of, but it's less known. It was a case striking down a Massachusetts law that restricted access to contraceptives for unmarried people. Remember, Griswold was really only for married people. So the imposition of the ban on unmarried people was challenged. Dr. Bill Baird demonstrated the use of contraceptives at Boston University and then was being prosecuted by Eisenstadt. And that case then went up to challenge the ban. And in that case, the court said, well, in a married couple, and this is a weird lawyer thing, right? That they even have to make this argument in this way, I find humorous about my profession. They said the married couple is made up of two individuals. And because you have these two individuals that have this right, it's unfair and unequal to oppose a different standard on these other individuals just because they're single. So they kind of had to describe it in this way. It makes sense completely for humanists who are devoted to the rule of reason. It makes sense. It's a good argument, but it's also, to me, one of those examples where the law requires a lot more fine-tuning and dissection of rights than really are necessary. Maybe I'm wrong about that, but I find it somewhat amusing. Also, in the gay marriage case, in Obergefell, the court said that the right to marriage is guaranteed to same-sex couples. That was the big case that guaranteed the right to marriage to same-sex couples. And it said that right was guaranteed, again, under that same right to liberty. But there was mention in that case about the equal right to liberty. So again, mentioning equality issues and liberty issues. And scholars who talk about this often point out the right to liberty and the right to equal protection of the laws are all part of the same sentence in the 14th Amendment. So if you want to get textual about it, which a lot of the scholars like to do, then it's all right there. And it makes sense that you can't have one without the other. Do you have questions you want to ask?
Why do abortions need to be performed in these designated clinics? Why can't they be done just in regular doctors' offices and hospitals and be a regular part of medical care for women? Wouldn't then this whole Casey shutdown of the clinics wouldn't maybe really be possible?
it doesn't have to be, and it shouldn't be considered a separate procedure that gets performed in separate facilities. It should be performed as a matter of course as part of women's health care. The reason it ends up being performed in separate clinics is precisely because of all these restrictions that we're talking about. Separate insurance requirements because of the restrictions and because of the litigation that can result. But because of all this and because of the stigma around abortion and around being an abortion provider, it's pushed abortion out of many ambulatory surgical centers where the later abortions could need to be performed. They need a little higher level of a kind of medical facility, pushing them out of individual doctors' offices where the similar types of procedures are happening. So first trimester abortions are the same. They're performed in the same way as a D&C, which is the kind of thing performed after a miscarriage, or in some women who are retaining menstrual product, blood, let's just say the word blood, during their regular cycles. So it's the same procedure, the same risks, the same safety, which is incredibly safe. It's safer, for example, than a penicillin shot, and people like to use that example. So there's no reason for it not to be happening in those places. There's no health reason.
Previn?
Thank you. I heard about Ruth Bader Ginsburg's issue, that she was not happy that this case was decided from the Roe issue. She was more interested in equal rights. The Major Struck, who was a famous issue before Roe. So perhaps you want to comment on that. Thank you.
Yes, thanks for the question, because it does allow me to go a little bit more into the equal protection questions. There are many scholars and also lawyers like Justice Ginsburg who argue that the right to liberty is an okay basis for the right, but the better way to look at this is that it's a sex equality issue. Now, I would argue that it's more of a sex equality issue for people who can get pregnant, partly not because it impacts not only their decisional autonomy, as the courts would put it, their ability to make decisions about their lives, but also their bodily integrity. So the person who is pregnant is the one who is most impacted by the pregnancy. There are many physical and emotional impacts of pregnancy that do not apply to the non-pregnant person. Now, one of the interesting things right now that is a challenge to lawyers, I think, and to the equal protection argument is the reality of transgender people. So a trans man who has a uterus, who is capable of pregnancy, then challenging restrictions on pregnancy based on gender and as a sex equality issue. Because in that respect, it's not a sex equality issue. It's not about protection of the woman's right because it's a trans man. So there are other ways to argue that issue, but that's been one objection that's been made.
Thank you so very much. I'm not sure you can hear everybody applaud.
Thank you. I mean, this is really fun. I love talking to the humanists.